How was it that the Bill of Rights' 27th Amendment was ratified over 200 years after being submitted to the state legislatures? How was a lowly student able to spearhead the passing of this amendment to the Constitution? And was he ultimately successful in appealing the C grade on his paper on this unratified Bill of Rights amendment? And what other forgotten amendments can be successfully ratified? Please, we welcome interesting questions in the comments. Let us learn and reflect together. At the end of our talk, we'll discuss the sources used for this video. Please feel free to follow along in the PowerPoint script we uploaded to SlideShare, which includes illustrations. Our sister blog includes footnotes, and both include our Amazon book links. Many citizens serving in the ratification conventions were wary that a strong federal government could trample on the rights of ordinary citizens, just as Great Britain had trampled on the rights of the American colonists before the Revolutionary War. The Constitution was ratified with the proviso that the first Congress would pass and submit to the states for approval a series of amendments, a Bill of Rights guaranteeing that the federal government would protect the basic freedoms of Americans. Based on suggestions offered in these conventions and in the national discussions, James Madison drafted a series of 20 proposed articles, which were modified and condensed into proposed amendments by Congress. Most Americans know there were 10 amendments ratified by the states by 1792, only 2 years after Congress proposed them. And we're familiar with many of these: freedom of religion, freedom of speech, right to bear arms, no quartering of soldiers in private residences without consent, no unreasonable searches or seizures, no double jeopardy, you cannot be tried twice federally for the same crime, and a right to a speedy trial and to a jury trial in civil cases, and no excessive bail or cruel or unusual punishments. Now, many people do not know there are 2 Bill of Rights amendments drafted by James Madison and approved by Congress, which were never ratified by the required 3/4 of the state legislatures in 1789. One of the amendments that had not been passed had been suggested previously during the North Carolina and New York ratifying conventions. And this was the amendment concerning congressional pay raises. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. So in other words, no pay raises before elections. This amendment was ratified by 7 states by 1792, short of the number of states required. Now, another action taken by the first Congress was the admission of 2 new states, Kentucky and Vermont. 12 states are the required 3/4 of the 15, which is the original 13 colonies, plus these 2 new states. Much later, 2 other states ratified the amendment as a protest against congressional pay raises, and that's Ohio in 1873 and Wyoming in 1978. This amendment was mostly forgotten until 19-year-old Gregory Watson submitted a paper in government class at the University of Texas, suggesting that it could still be successfully ratified, as the original Bill of Rights amendments had no deadline. The teacher's assistant grading his paper ridiculed his research, saying that ratification would be totally implausible, giving the paper a C grade. He appealed the grade to the course instructor, Sharon Waite, who sided with the hapless teacher's assistant. Now, what were the Supreme Court rulings on when proposed amendments expire? Dr. Wikipedia informs us that in Dillon v. Gloss, 1921, the Supreme Court remarked that ratification must be within some reasonable time after the proposal, and suggested that it was untenable to view amendments from 1789, 1810, and 1861 as still pending. But in Coleman v. Miller in 1939, the court ruled that the validity of state ratifications of a constitutional amendment is a political matter, and thus not properly assigned to the judiciary. It also held that for a political question, it was up to Congress to determine whether an amendment with no time limit for ratification is still viable after a long time based on the political, social, and economic conditions which have prevailed during the period since the submission of the amendment. How could our lowly student Gregory Watson prove that ratification was a plausible quest? By starting a letter-writing campaign seeking ratification, and he eventually spent $6,000 of his own money on this quest. As a first step, he wrote to select congressmen, asking if they knew of any state legislator who would like to introduce a resolution passing this amendment. A congressman from Maine replied that one of his staff members, who was also a member of the Maine state legislature, was interested in the quest. He introduced the ratification resolution to the Maine legislature, and it easily passed, giving our student credibility in his quest. Maine passed the amendment in 1983, followed by Colorado in April 1984, and over time he was assisted in his quest by Ralph Nader, the Washington Post, and several congressmen and activists. The cartoon is about the Salary Grab Act of 1873, where Congress approved a retroactive pay raise for itself. Now, 9 years later, Michigan and New Jersey vied to be the 38th state to ratify the amendment in 1992. Over 200 years after James Madison first drafted this proposal, this final Bill of Rights amendment was passed as the 27th Amendment, a record-breaking ratification process that took over 200 years. Now, in 2016, Professor Zach Elkins at the University of Texas became interested in this recent history, tracking down Sharon Waite, who left academia about a decade after Gregory was a student to work on her parents' citrus farm. When asked whether his grade was fair in hindsight, Sharon Waite said, "Goodness, he certainly proved he knew how to work the Constitution and what it meant and how to be political active. So, yes, I think he deserves an A after that effort. A+. So Elkins and Waite submitted a grade change form to change Gregory's class grade to an A+. And that same year, the Texas legislature passed a resolution commending Gregory Watson's efforts in spearheading the effort to pass this last amendment in the Bill of Rights. But regarding the teaching assistant, his name has been lost in the sands of history, as digging it up would serve no purpose. Now, what was the 12th proposed amendment of the Bill of Rights passed by Congress but never ratified by the states? It was a somewhat complex amendment refining the ratio between representatives and the population, with a maximum of one representative for every 50,000 constituents. Now, based on the 2020 census, this formula results in about 6,600 representatives in the House, which is way too many congressmen. And so the passing of this amendment is, indeed, implausible. There are a few outstanding amendments that theoretically could still be ratified. One is an 1810 amendment stripping citizenship from anyone accepting a title of nobility without congressional approval, which means, for instance, that you cannot buy the square foot of land to qualify as a Scottish nobleman. Also open for ratification is the 1924 Child Labor Amendment, which enables Congress to directly regulate employment of children under 18 years of age. Now, federal and state legislation eventually ended child labor by the New Deal era. Now we'll discuss the sources we used for this video. Along with this reflection, we reflected on how the Constitution, plus the Bill of Rights, improved upon the Articles of Confederation. Our primary sources for this reflection are various articles collated by Dr. Wikipedia, plus the YouTube videos and articles in the footnotes, including several live interviews with our famous student Gregory Watson. And he has an inactive page on LinkedIn if you want to try and friend him. Many critics contend that this amendment accomplishes little. Although Congress previously passed legislation automatically increasing their pay each year by COLA, or the cost of living adjustment, it has voted to decline this annual raise each year since 2009. And currently the congressional pay is $174,000 a year. The YouTube description includes a link to our PowerPoint script that we uploaded to SlideShare and also our blog. Please support this channel by sharing this video with your friends and by clicking on the like and subscribe buttons and by clicking on the Amazon links to purchase any of the books we discussed, which will earn us a very small affiliate commission. And please consider becoming a patron of our channel. Plus, we will host special discussion groups for our patrons. Plus, you can click on the Meetup or small M icon to participate in our online discussions, where we practice our future YouTube scripts. And please click on the links for other videos that will broaden your knowledge and improve your soul.